All right, jury selection. This could be a seminar in and of itself, so I'm just going to hit some of the key points. But what you have to do in jury selection is not listen to your self-talk as much as try to get the jury to talk about themselves, their experiences, what they're thinking, and what they think about your case. I spend the majority of my time talking about the negative parts of my case. The negative parts of my case, because I want to find people that are going to react strongly to the negative parts of my case, so I can strike them. So I don't try to support them in terms of, oh, you're wrong. I don't try to correct them. I thank them for their honesty. I encourage them to trash me, trash my client, trash my case, tell me why they think it's poppycock, or they can't award damages, or they won't award damages in the high range. I try to get them talking about all those things early, because I want to know now. I don't want to be surprised later. I want them to tell me that. So I'll ask questions that are open-ended. I use the Oprah Winfrey method, where I ask one juror to comment, and then somebody else comments, and I ask, well, what do you think about what he just said? Why do you feel that way? I try to get the jurors to interact as much as they can over the key issues in the case on the negative side for me. Now, why am I doing that? Because I'm trying to deselect the jury. I'm not trying to find my friends. I'm trying to find the people that are worse for me. I want to find Hitler, Fidel Castro. I want to find Chavez, who's already dead. I want to find Dracula. I want to find Frankenstein. I want to find all these bad guys. Jack the Ripper, where are you? And sometimes Jack the Ripper is dressed up like a nice little lady, so you can't really tell. You might think, oh, she looks like such a nice lady. In reality, she's ready to rip you. You have to ask the right question. In fact, I'll give you an example. I had a case involving another rollover where a 12-year-old girl suffered severe brain damage, Phoebe Jimenez. And there were these two very attractive women. I still remember where they were sitting. Second row in the middle. Really cute. And they kept smiling at everything I said. I said, man, these are going to be great. They're going to be fantastic. I was all excited. And then I asked, I asked open-ended questions. How do you feel about awarding damages for pain and suffering, for the mental anguish? And they answered, oh, no. No, we can award for medical bills and economics, but that concept of pain and suffering, that's not for us. Both of them had the same feeling. But I asked them, and I asked them in depth, how do you feel about it? Why do you feel that way? And how long have you felt that way? You're not likely to change your mind. So they ended up being stricken for cause because they couldn't award significant damages for pain and suffering. It was a concept foreign to their gut belief. They couldn't do it. So you got to ask the question. And it's not how they're looking at you and that, oh, well, she likes me, she's smiling at me, or he really likes me, he's smiling at me. It's not true. You got to get in there and you have to ask the questions. And you can't stereotype at all. I'm going to give you some really scary examples of things that I did that worked. And I know they work because of the verdict. It used to be that you couldn't have bankers or accountants. I love bankers and accountants because they know numbers. They know the value of money. When I started practicing law, J.B. Spence's philosophy was ruled the day, which was the haves versus have-nots. You want have-nots on your jury. That's no longer the case because have-nots don't understand money. So they may think $150,000, hey, I just gave that guy $150,000, a lot of money. That's nothing for the injuries and cases that we're talking about. So you want people to understand the value of money, that know what it means. That's critical. And find out where they're at personally. Do you have a problem awarding damages, Mr. Banker, Ms. Accountant? Do you have a problem with that? How do you feel about that? Why do you feel that way? You have to ask those types of questions. The scariest thing that I ever did, here's what it is. I had a failure to diagnose breast cancer case. The doctor died before trial. Dead. The PR was the wife, a lovely lady who was sitting there looking lovely without her husband, who I am suing. Terrible, right? Yeah. All right. So here's the situation. One of the juror members on the panel was an insurance adjuster. Scary. I'm telling you, this is really scary. This is like you're in there and there's a wild beast and he's going like this to you, and you don't have a gun. You just got like a little whip or something. And you're convincing this guy, okay, I need you to work for me. Can you do that without eating my head? Here's what I'm thinking. Of course I was scared, okay? This is a very scary moment. Jury selection in and of itself is always scary. Very scary moment. Jury's sitting there looking at this poor lady who lost her husband that I'm suing. If this adjuster gets on and can be fair, he will tell them, don't worry, Gonzalez wouldn't be suing unless there was insurance. And you see that guy with the ugly suit in the back there? That's the adjuster. That's what I used to do, monitoring the trial. So you'll be fine. That was my philosophy. So I was working this guy over and over from every angle. How do you feel about lawsuits? What do you think about lawyers? What do you think about caps on damages? How about all these lawsuits involving medical negligence? What's the impact on that? Were you defending these cases? How long were you defending these cases? And he kept giving me good answers. Good answers. And I started feeling, it's probably worth the risk. And it was. Because at the end of the day, we ended up getting a very large verdict. And it worked. So the stereotypes don't work. You can't just say, oh, this person's conservative or this person is liberal. You'll be surprised. Sometimes people hate Tea Partiers because they think they're too conservative. But they're also independent-minded people that believe in accountability and responsibility. So if you get that right thinking and you get them there, you have to ask questions. But just because that they're ultra-conservative or Tea Partiers that you can feel doesn't necessarily mean they're going to be bad for you. You have to ask the questions. You've got to get in there and ask the questions. So, example of questions. How many people think there are too many lawsuits? Why do you feel that way? Does anybody believe that lawsuits are bad for America? Do they increase insurance rates? How do you feel about that? What do you think about lawyers that bring these lawsuits? What do you think about people that bring claims for injuries? You think it's wrong? When is it wrong? Why is it wrong?
What do you do to get a back answer?
I encourage it. I encourage it. I thank you for your candor. Thank you for your honesty. I appreciate that. You're not likely to change your mind. Correct. Now look at the judge. Cause. Next, how many people agree with what she just said? Raise your right hand. And they raise your hand. And then I start knocking them out. Bam! Juror 7, Juror 15, Juror 13, Juror 8. And I follow up with those questions. You feel the same way? Yes, you agree. See, now I go from an open-ended question to a leading question because I'm going in for the kill. Open-ended question, I'm throwing out the net. See what comes in. How many people believe this? How many people believe that no matter what the damages are, it should never go over $1 million? How many people believe that? How many people can't award anything for mental pain and suffering? It's just a concept that's just too hard to understand. See, my fear is I may not ask the question the right way, but I know that a lot of my own family members, they think, well, I can award for economics, but this pain and suffering concept, I don't know. How do you award for mental anguish? I think I can't do that. And my fear is if I can't get you thinking that, talking about that, honestly with me now, that'll be a problem. So can you share that with me? How do you feel about it, sir? And then he'll tell me. How do you feel about it, ma'am? And I may get you talking a little bit. And then I'll ask him, do you agree with her? Do you agree with that? Does that make sense to you? Why do you feel that way? How long have you felt that way? And I encourage it, and I thank them. Thank you for your candor. I appreciate it. Thank you. Why am I thanking them? Because I'm getting them off of my jury. They're gone for cause. I don't have to even use a peremptory strike. They're telling me they can't be fair. And I'm so grateful. I really am. Yes, I am grateful. Then I have my law partner sitting at the counsel table looking. Is somebody rolling their eyes at me? Not in a good way. Are they smirking? Not in a good way. Let's check out body language. You have to be careful with body language because it doesn't always mean what the people tell you it means. If they do this, you're always bad. If you do this, you're hiding something. Not necessarily. You have to see. So there are a lot of different factors. But you have to get in and talk about the negatives. Absolutely. Your client had a drinking problem. You know it's coming in. Or your client had taken an illegal substance. You know it's coming in. Talk about it. Some people have a very hard time dealing with anyone that has had drug use, illegal drug use. Some people have very strong feelings about that. If this case deals with illegal drug use and to any extent, would that affect your ability to be fair and impartial to the plaintiff in this case, if that were to come out, something like that? How many people feel strongly about that? Boom, 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 boom. And then you thank them. And you tell them you appreciate it. And you ask them for how long they felt that way. They're not likely to change their mind. Now, so you go in with the leading questions. You felt that way all your life, sir? Yes. You're not likely to change your mind, are you? No. It's something that's strongly in your gut. Yes, it is. Thank you. Boom. Look at the judge. How many people agree with what he said? Why? To go over that. Go over your problems with liability. You can't. A lot of judges don't let you talk about the case, but you can talk generally about issues by asking, has anyone ever had, for example, cancer? Has anyone ever lost anyone in an aviation accident? Has anyone ever been involved in an electrocution issue or burn issue, whatever it might be? If it's a commercial case. Anybody do commercial litigation here? Yeah. Commercial case, I use a lot of responsibility themes with promises, meeting your promise, meeting your honor, living up to your end of the bargain, breaking the promise. I deal with those types of things. I love this theme, and I use it all the time. A lot of times people don't get paid what they're supposed to be paid, either through a straight breach or through a dispute over the quality of the services that were provided or the quality of the goods that were provided, or UCC issues. They're saying, well, it wasn't a good that I could accept because it wasn't the quality that was represented, or warranties. And I use something very simple. I talk about we did the work, we sent it over to you, and you kept the money. You never paid us. That's un-American. I mean, here in this country, we do the work, we get paid, right? Okay, so we do the work, you keep the money. Something's wrong with that. And if that's my theme, and I did it with Martha Stewart towels, we tried that case together, and I've done it with some pathology cases where insurance companies try to rip off my physicians, not pay them their full amount. And I used it in 1988 when I got my first multi-million-dollar verdict. I was 28 years old, and I hit on a theme of, we did the work, you kept the money. $4.5 million. Radiology group did the work, and then a new hospital purchased the hospital. Then they argued that they were entitled to all of the income that the hospital made during these years, but my client was actually had its own contract. They were not employees of the hospital. So a big dispute arose over where those funds should go. And there were Medicare funds. So it was $750,000 that went through Medicare to the hospital and stayed in the new hospital's bank account. I actually transferred it over there. And they were arguing all these things with a contract. Well, we're entitled to the monies this way and that way and this way and that way. And here's why it goes to us, and all these provisions and all these bylaws and all these fancy accountants. And I said this is a 5-document case. Here are the bills that we generated for the work that we did. Here it is going to Medicare. Here's Medicare acknowledging that they're going to pay it. Here's the wire where it was transferred. And here's the bank statement showing that the money's sitting in the defendant's account. So they were coming in with, they had like close to 100 exhibits. I had 5. I told them what they did was they created a haystack to hide the needle. And it's a 5-document case. And I said, my clients did the work, and they kept the money. And I would actually even point. See that guy over there with a suit? He's sitting there with my client's money. Yeah. It was simple, but it was true. And it was a very simple theme. But I started it in jury selection. How many people feel that it's okay to do the work and not get paid? Have you ever been in a situation where you work and you don't get paid, or you're not paid the full amount? What do you do about it? Do you think that's fair? Why do you feel that way? The obvious questions that bring people up and thinking about what it is that you're going to be presenting. It's important to do that. Okay? Yeah.
Working your theme in on liability, we talked about in blood here, which you just hit on. But what about damages, like Isabella, loss of opportunity or something like that, or preparing the jury for a big number at the end? How do you work that into blood?
Well, in Isabella's case, that's a little girl that lost her toe, her big toe. It was her big toe. Okay, so that case walked in the door, and I said, this is a 7-figure case. A lot of my colleagues thought I was crazy. Well, it's just a toe. I said, no, it's not just a toe. It's her toe. And it impacts her ability to play tennis, to dance, to cheerlead, to go to the beach, to wear her shoes, to wear pretty shoes that show the toe, to wear sandals. It's a big case. And I started thinking of it as a big case. If I thought of it as a small case, guess what it turns into? Small case. If I think of it as a big case and I work it up like a big case and I treat it as a big case, what does it become? Big case. Right. So I worked with her coaches, her tennis coach, How did her tennis change? How important is the toe for the lateral movement? I worked with her with a dance instructor. I had her evaluated by a former Heat dancer who also danced modern dance and was a cheerleader coach for high school. And I took videos of her falling all over herself, poor little thing. I worked with her with all of the people that she dealt with on a day-to-day basis. I had pictures of her hiding at the beach, hiding the injured foot behind the other leg, always, or wearing socks, always. And the defense was, oh, she's functional, she's a happy girl. She's fine. It's not that big of a deal. Well, it is, because it's her toe. You work with the jury the same way. What activities do you do? What activities do your children do? How important are those activities? How important is it to be healthy? Are the feet important? Why are the feet important? Anybody ever have a problem with their feet? Anybody ever have a problem with their toes? Anybody been involved in heavy athletics? What lost opportunities? I mean, maybe she would be the next tennis champion. We don't know. Maybe she would be the next ballet queen. We don't know. Or maybe it would be her favorite hobby and now she's not going to be able to participate at that level. We don't know. They're stealing that from her. And that's going to cause and does cause anguish and pain and trouble. So I can't share the exact amount we settled, but it was a 7-figure case. Because it is. It's not magic. What we do is bring out the value, whether it be a commercial case, a product liability case, personal injury case. We bring out the value of the case, and we show it in a concentrated form without the fluff. Here it is. Here's the white part of the coconut. I'm going to show you the whole coconut because that's not what we're talking about. We're talking about the white part of the coconut. Here it is. Let me show it to you. So that's what we do. And I started in jury selection, open-ended questions, and then when I go for the kill, for moving to strike, short, tight, leading questions. Any questions on this part? Okay. You want to start on opening? Yeah.
So it sounds like when you find that one juror that you know you don't want on your jury, you get to a point where you know you've done enough to strike them, and you move away from that. Is that? I mean, am I getting that from you?
Do you ever fish for dolphin? Mahi mahi?
Yeah.
Okay, when you catch the first fish, what do? Leave it in the back of the boat, right? Because what happens? The rest of them follow.
Right.
Yes. So I leave them behind the back of the boat and I wait for the rest of them to follow. I start asking people, how many people agree with him? Why do you agree with him? And I start getting the rest of the dolphin hooked so I can get them out. So I don't just stop and move on. I stop there, leave you behind the boat, and I encourage the rest of the jurors to tell me why they think that you're right.
That initial juror, are you concerned about maybe that person tainting the rest of the jury?
They're already tainted. It's my job to find out where they're at. Nobody's going to form a strong opinion for or against me in those few hours of jury selection or few days of jury selection. They either came in with pre-existing prejudices for or against me, or they didn't. And it's my job to find them. So I don't believe they're going to taint or poison the jury. We all have very strong beliefs. We really do. I mean, I know I do. And I suspect you do. And nobody's going to change your mind in a few hours one way or the other unless you agree or don't agree. Yes?
So when you're creating pain with the jurors, with the open-ended questions, how do you handle opposing counsel and their objections to your questions?
They can't object to that. It's legal. They're perfectly proper questions. They just have to be related to the themes, issues in the case, bias, credibility, ability to be fair, impartial, on all of these things. And these are all elements of the cause of action, so you're entitled to get into every single one of these things. There's case law that says that if a court limits you, it's reversible error, including if they limit you unreasonably on time. And you know how they try to rehabilitate? They come back and say, well, you didn't really mean that. You're going to be fair, right? You're going to follow the law, right? Oh, yeah, I'm going to follow the law. There's a case that says once you show doubt, you can't take it back. And you have to be ready with those cases for the judge. So you can talk to the judge, say, Judge, this lawyer said this and this and this. It's important that your colleague be taking notes on what the jurors said and did. Because you want to be make sure you have everybody and when you make your challenge for cause. Do I have a little more time on cause?
Yeah.
Okay, to preserve your challenges for cause. This is important. Let's say, hypothetically, that it's a 3-strike per side. And let's say you ask to challenge, I'm going to challenge you for cause. Because he said he couldn't be fair, Your Honor. He said he couldn't award damages in this kind of case, or he said he couldn't consider awarding because I have one plaintiff is over 25, the other plaintiff is under 25 under the Wrongful Death Act because one brother can recover, the sister can't. He can't do that. He's not fair. You deny it. Okay, denied. All right. You should be out for cause. Those are good cause reasons. He denied it. I have to strike out. I have to move and strike the 3 people I'm going to strike. 1, 2, 3. And strike these 3. Okay? I'm out of strikes. Now I have to say, Your Honor, I request an additional peremptory strike. Why is that, Mr. Gonzalez? Because you wouldn't allow me to strike him, and he said this, this, and this, and you wouldn't allow me to strike him, and I'm prejudiced. And who is it that you would strike, Mr. Gonzalez, but for that? Right. I would strike him, Your Honor, and here's why I would strike him, and I need additional peremptory. Now, denied, the issue's preserved. The judges know the case law, so if you set it up the right way, they're going to usually grant it. They're going to give you the additional peremptory strike. If you blow it by not setting it up the right way, the judge is going to deny it and not go ever back to it because it's convenient. Just move on. You didn't preserve it, not an issue. If it's not preserved, it's not an issue. This is how to preserve it. So everyone got that? That's important. Okay? You get it? Okay. It's critical. If you don't do it, it's waived, and the judges are real smart about it too. All right. So I'm going to turn it over to...
One quick question. What's the strategy on back strikes? And not using all your strikes on the first round, and you've got your jurors set up, you've got a room like this, and you've got your grid with 40 jurors on, you've gone through and you've struck the jurors 5, 6, 8, and 12. And you get to the point and you say, well, I've got 3 strikes left, but I know this defendant's going to strike these 4 probably. What's the philosophy in the mindset?
Well, a lot of times it's a game of chicken. Sometimes it's the first 6 are up, and nobody objects, nobody strikes, waiting for the other side to strike, because you can always backstrike in Florida. Federal court's different. Florida allows you to backstrike. State court. You always have the right to backstrike, up until the time the jury's sworn in, frankly, which really upsets the judges when you use it. So don't. But don't wait that long. But we're allowed to backstrike.
Here's a question from our attendees. They would like to know about...
Hold the question.
If you can give them some information about taking notes from the questions that you're asking your denier without stopping the discussion that's going on.
Okay, I will get to that. Hold that question.
Yes.
You'll bring it back to me. So what I often do is, look, if I have Hitler or Dracula on my jury, I want to get rid of them quickly. So I usually go right for the kill and strike them right away, but for cause. And sometimes the judge will have you go row by row on challenges for cause. But if I'm iffy on someone, and sometimes I try to bait my opponent by masking that I really don't like this juror. Maybe I really don't like that juror. But I'll give you setup questions. Like, you'll be fair, right? Yes. And if the case isn't that valuable, you wouldn't award a lot of damages, right? But if it is, you will, yes. And I started to create questions that I may really like this guy. And then I'm hoping that my opponent will strike him for me. Sometimes it works. So I'm not too quick at striking everybody. I hold back. I let it develop. I let the play develop. Who are you going to strike? But I already know, I put it in my map. These are the 3 worst that I must strike for cause. These are challenges for cause that if I don't get, I'm going to have to absolutely use one of these for cause. And I know it going in. And that's how I strategize it. All right, so the question is, the question was, what...
How do you keep taking notes and noting what's going on without breaking your flow?
I work with an outline in my head a lot. And I try to follow through that outline. And I try to remember people that fit into the outline where I have it in my head. And then my colleague may be writing specific notes on the counsel table as to what the person said or did. If it's important enough and I feel it's extensive, I will stop. I will thank the juror, and I will literally write down a note to myself on what that juror said, because it's that important and it's something that's not going to stick. It's not in my head outline. But that's how I do it. But it's okay to stop and write down a note and say, thank you, I appreciate that. That's important. And you write it down. Acknowledging that what they're saying is so important, you're going to write it down. Yes?
Where's the fine line for you with being too informal, the jurors are not formal?
Be yourself.
In the sense that, a lot of people
Repeat the question.
Learning the jurors' names to make sure obviously you're pronouncing them correctly, and you're remembering them and going back. And, there's this fine line between being too informal but yet being formal enough so that you can, your profession.
Question is, when when you're doing jury selection, what's being too informal versus formal. Some lawyers actually know the jurors' names and they read them back. I think you have to be yourself, whoever you are, personality-wise. Who you're seeing today is pretty much who you see in trial, pretty much who you'd see if we went out to dinner with our significant others. That's who you see. I'm pretty much the same person. And I think that one of the reasons lawyers are successful or not successful is the successful ones tend to be themselves and are very comfortable being themselves. I've seen lawyers that are absolute jerks and get tremendous results. You know why? Because they're themselves. They're absolute jerks all the time. The phoniness doesn't work. So if you're an absolute jerk and you try to be a nice guy, it doesn't work. Or if you're really a nice person and you try to be too hard, it doesn't work. You have to be true to yourself. We all know courtroom decorum. We all know what we can and can't do. I don't try to remember the jurors' last names. I think it creates too much stress and puts too much focus, for me, on trying to remember names rather than trying to get out what I need, which is, to me, is more important. Other lawyers are very comfortable immediately learning the names and using the names, and they think it's a cool shtick because it shows the jury how smart they are. And it works for them, and I think that's wonderful. But for me, what's important is to learn what the jury's thinking, what they're saying, how they're saying it, and I don't really worry about it anymore. I used to think it was really cool to do it, and then when I thought about the philosophy of jury selection, I realized it's not that important to me. So that's the answer to the question.